Okay. Good morning, good afternoon, good evening. Welcome to the Woven Threads Fashion Business Series 2021, which is being organized by the Lagos Fashion Week and Style House Files as part of their 10th year anniversary, celebrating the burgeoning fashion scene and the importance of fashion within the economic activity of Nigeria, Africa as a whole. Today, we are talking about protecting creativity. And with me to have this particular conversation today are, they've heard my legal luminaries joke already. Kike has heard it, but I really want to say it again. So I'm really happy to have Busola Bakinson, Toby Moody, Kike Ojewale, talking from the legal and design perspective about intellectual property. And with us as well is Laduma Ngxokolo, see, after on my mouth, Ngxokolo, who is one of Africa's finest and most innovative designers. He manages to fuse traditional Koza knit designs in premium knitwear and has shown all over the world and collaborated, on a grand scale. So Laduma is actually a really good example of what we talk about when we are looking at creativity as a mechanism for driving economic activity, because he controls his design process from the beginning to end. So before we get started on questions, I just want to sort of give a little bit of context into the conversation and what we're hoping to get out of it today. We live in a world in which a design can be transmitted around the world in minutes and can be replicated or copied and hit the markets in a matter of days. So our objective with our time today is to share of the thinking about just exactly how the law is evolving to protect what is effectively a psychological process, that is to say creativity, which is made concrete through innovation, which is a thinking or thought process, and becomes material in design. So as I said, we've got the gamut of experts to talk about this. In particular, Toby, Kike, and Busola all have a very, very strong grounding in intellectual property and design. Busola represents a number of brands who are dealing with this across the continent. Toby is speaking from a global perspective in terms of what is happening, across the whole world. And Kike manages to fuse intellectual property in the creative space in a very, very creative way. It's actually something that I've watched and I found really fascinating in how she manages to please herself and her parents at the same time. Not many people get to be able to do that. So before I ask you, Laduma, so this first question is really for you. There's a psychologist called Dean Keith Simonton, who is really sort of one of the foremost researchers on design and creativity. And he says that you can't be creative unless you come up with something that hasn't been done before. The idea has to work, be adaptive, or be functional in some way. It must meet some criteria of usefulness. So for you, I would sort of like you to just talk a little bit about your process, because what today, if you recall, what we're trying to identify is how this process can be protected in a way that assures revenues and ultimately intellectual property. So please, if you would, Laduma, just share a little bit about your design process and the design process of Makosa Africa with us.
Thanks, Tola. Sorry for that. I have to say on my side, for the first part of the statement from the psychologist's philosophy, is that I beg to differ on the part that in order to be creative, one has to create something that has never been seen before. I say so because in my case, what I'm doing has been seen before, but a combination of things, it is a combination of things that people have seen before, but in a way that they've never seen before. So technically, my design process began with me taking references from traditional Xhosa beadwork. As you might know, Xhosa people are the second biggest cultural group in South Africa after the Zulu people, Nelson Mandela being one of our prominent figures. So one of the things that we are known for is our colorful beadwork. And our beadwork is so graphic, it's so bold, it's so distinctive, it's easy to see, and it's magnificent. So I technically take those motifs and patterns, but I reinterpret them in my own way, in a way that I feel like it would be appealing to the youth that still wants to be cultural, but in a modern context. So I basically applied on a lot of products, on carpets, on cushions, on throws, on wallpaper, and in endless possibilities. So for me, yes, knitwear has been around for centuries. Furniture has been around, fabrics has been around, but my approach was different in the sense that I rather innovated the small bits that were combined in things that already existed, but it appealed in a new way, and it became a story that is relevant and a story that closed the gap for the African luxury. So that has been my story, and I believe that I didn't have to innovate much, but I had to think carefully on the relevance of what I was doing.
Okay, so you didn't reinvent the wheel, but you changed the spokes a little bit, and the hubcaps are entirely unique to Makuza, right? That's kind of what we're saying.
Absolutely.
So Busola, from what Laduma has just discussed, I think the question I want to ask you is how important, before I even say it's important, how is it possible to protect this process that Laduma has just like outlined for us?
Okay, thank you, Tola. Truly, in Nigeria or internationally, there's a good overlap between various. I mean, you can protect your designs or your process. There's a good overlap when it comes to international registration. But for Nigeria, if you look at our act, and that's just because our provisions, our laws are very outdated, if I can say that. So there are different ways in which you can protect that process. And then you have to make sure, and that's why it's important again to speak to an expert, because they can then decide and let you know what kind of provision or protection you should get. So for Laduma's designs, for example, if it's a process that he works with, he can then start to look at a patent to protect that process. So if it's a different process from what already exists, like he said, because one of the characteristics of patent is that it has to be new. It has to be something that has not been in prior art. And what is prior art is that it has not been anywhere out there, for example. And the test is not even only a local test, it's a global test. It has to be something that you have to ensure that globally it doesn't exist. If he talks about his designs, for example, he then starts to look at the Designs Act. He then starts to look at copyright, for example, but he needs to be careful again, and for every designer out there, because like I said, there's no overlap in Nigeria between copyright and design. So in other jurisdictions, there's a good overlap. I can protect on that copyright as well as design. But for Nigeria, under the Copyright Act, Section 12, I think, says that you can protect it's design is an artistic work, right? That's first under section 1. But when you go down to other parts of copyright, it says it cannot be a model or something that is intended for industrial, multiplied or for industrial application. Then you see that you're stuck right there. Because a design is something that I want to multiply, it's something that I want to, put out there. So I'm stuck right there. But you can then take advantage under the Designs Act, because then that allows you, under the Designs Act, it has to be something that will be multiplied for industrial application. So you see that there are two different spectrums when it comes to the laws. So for example, if you've rushed, if Laduma rushes to say, oh, I need to protect my designs of that copyright, and then he decides, when it's time for enforcement, he then says that, oh, another party says, well, you've produced these things in different places, 100 production, copyright doesn't cover you in that aspect. So I'm sorry, there's really nothing you can do, but if you're taking advantage under copyright, you can start to talk about your sketches to say, oh, my sketches, I will protect that under copyright, for example, but then other designs should look at design. So, like I said, you really need an expert you need to discuss this with an expert. They can then decide and fine tune where you should be looking at. So there are different ways in which Laduma can protect his processes and his designs.
Okay. Thank you, Busola. My next question is actually for Toby, because what Busola has outlined is a very she's given an overview of an area that is still evolving. It's being birthed. And because I had talked earlier just about how technology and the breakdown of barriers and boundaries and the way in which images and designs can spread in literally minutes. So it's an evolving field, and it will address issues that will encompass the life of a piece of clothing from origination all the way to brand assurance, right? And the clients for such would be design houses, wholesalers, tailors, modeling agencies, retailers, photographers. Can they all access experts? Do they all have access to experts? Do they all need this expert advice? So I guess the question would be, what stage would you say that fashion law was at globally first? And then if you can, tell me a little bit about where you feel.
All right, thank you so much, Tolagbe. I think that's a very tough question, but very hard to put a pulse on the temperature of the evolution of fashion law as it is now. I agree with you that it's one of those areas that's still strongly evolving. It's still one of those that you see different countries adopting different approaches. But before I even touch squarely on that, I think something that struck me from Laduma's story, which again just points to the way this is evolving, iteration for some of the designs of the work from tradition. That's again another interesting dynamic as he was speaking that just flagged, as part of the conversations going on around protecting things like traditional cultural expressions, which again play out into the fashion world in a very strong way, as we see today, where designers rely on or draw inspiration from local communities and their colorful attires in the way they weave together original designs. And so I think again, just to point out how complex sometimes these questions could be, as we try to think about the evolving landscape. Now, I think what we have, maybe from a Nigerian perspective, I do think that Nigeria has really come of age. This is my personal assessment. I think that Nigerian fashion stands out, not just here, but I recall a colleague at work, for instance, in Geneva, mentioning to me that she actually flew into Lagos to get her wedding gown made by a certain Nigerian designer. And I found that fascinating, just to hear how someone left, all designers in Europe and chose to come and I just found that there is a lot of emphasis actually being placed on fashion in Nigeria now. I think that we have really put out the brand just in terms of our creative and entertainment industry through the way our culture is displayed in attire. And so I think while it's an evolving field, I do think that the practice in Nigeria around fashion law is doing a lot to drive those conversations. I'll stop here, but I'll actually respond, as we move on again. Thank you.
Thank you. Kike, would you weigh in on that? Because you are, and I teased you earlier, because you do actually really sort of straddle those two worlds in an admirable way. So where is fashion law right now, and in Nigeria specifically?
Thank you. Sorry, I missed the last bit of your question. My Wi-Fi just keeps going in and out. I'm sorry about that. Can you?
So I wanted to
again,
ask you, like, in terms of fashion law, where is it at? So Toby sort of given us a global perspective and sort of emphasized what we were talking about. If someone's flying in from Geneva to access designs in Nigeria, they've seen that they didn't visit Nigeria before they saw the designs, right? So we're actually, buttressing the point. Where are we at in Nigeria specifically with fashion apparel law in terms of specifically, because it looks at clothing from origination to brand assurance. So where are we? Where's our body of knowledge?
Okay, so I would say that we're still in the very early stages, and that's just my personal opinion. But I do have to say that there's just a general awareness now about, these laws generally. So trademarks, copyrights, just, everything with respect to protecting your designs, creativity, all of that. There's definitely an awareness now. I think people in the industries, in the various, they're being a bit more particular now about protecting their work. I think there's also more of an awareness now about copying generally and in infringement generally. So I would say, what people wouldn't have considered, to be honest, in infringement years ago, that dynamic, that mindset has sort of shifted a bit. But I think that's also because of the growing industry as a whole. I mean, it's safe to say that our fashion industry in the last decade, I think, has just sort of, the global recognition has been phenomenal, not even just Nigeria, but Africa, really as a whole. So, but I would say, that being said, that we're still very much in the early stages. And the reason why I would say that is because I think our laws are, it's a fact that our laws are outdated. However, we've had this discussion before, and I remember saying that this isn't necessarily a problem that's unique to Nigeria. Yes, our laws are outdated, but laws surrounding fashion generally are not very adequate, and that's a global issue. You find that we're having most of these foreign brands constantly at war with each other. You have Zara that's, at war with Gucci, and, H&M, fast fashion is a real problem now. So it's not a problem that's necessarily unique to Nigeria, but to respond to your question specifically, I do think we're still very much in the early stages, just because the laws are there, but they're slightly outdated. So even having to apply the laws to the unique situation and the unique, I would say the situation, our unique market as well, I think that's a bit of a challenge. And I always say this, it's one thing to understand your rights, your IP laws, but it's another thing to be able to actually enforce them. A right is really just a right if you cannot, it's really just something on paper if it can't be enforced. So we also have that problem with enforcement generally in Nigeria. And also, again, it's not unique to fashion. That's IP generally. We have, challenges and enforcing trademarks and all that, also because of our slow legal system. So there are quite a lot of things that sort of contribute, but I will say that it's a steady progress. It's a bit slow, but it's getting there. So early stages, definitely.
Okay, thank you. So I think you guys have raised a number of questions, and something that struck me, because Kike kind of, you jumped ahead to like question 4, by the way, when you started talking about Zara and high school and design.
My apologies, sorry.
I just put an alefico right here, but okay, because the point is copying in and of itself. Laduma, we traditionally had a culture here, and the internet has kind of disposed of this, but people made money from aggregating photographs taken at high society events, which would then be put into publications that would be sold in traffic and sold to fashion designers and seamstresses, right? And so the process then was, you'd go to the seamstress and she'd bring out all the magazines and you say, give me this top with this skirt and this, like this sleeve, right? And honestly, no one thought anything of it. And I guess this is part of the whole, like, we're also woke now about everything. We didn't think there was anything about it. And when you think about it, clothing, and so lawyers, please bear with me because I'm going to do layman's sort of referencing of law now. Clothing is considered a useful article, right? So technically you can't copyright a shirt or a pair of trousers. But I think what you're saying is you can patent a design of a particular zip. Would that be correct, Busola? Or what would you do that your zips are different from everyone else's zips, for example? What's the process behind making that? Because let's just to quickly talk about Laduma again. Laduma takes designs from beading and reinterprets them in palettes that are perhaps more modern, more in line with what the youth want. So that's iterative process. How do you now get very specific? I want to patent my shirt, or I want to know, I don't want anyone to copy my shirt. This shirt, what do I do about it?
Okay, that question is for me, right?
Yes, it is.
Okay, yes. So maybe not patent.
Yeah, so tell me what
that's what we're
that's what I'm saying. Tell me what
I know
about my shirt.
Yeah, so basically you'll be looking at the Designs Act, and that talks about 2 to 3 dimensional, the aesthetics, the ornament. So that would really be a design. So your zip is done in a certain, so everybody's zip would go up, but yours would do like a zigzag and then come down and go up before it goes up again. Something just very different. So that would be you looking at the 2 to the 3 lines dimensional works, lines and the like. So that would really be a design. But what can be patentable is the process of making that zip. So if the process of making that zip is different from what exists out there. So if you have a certain process, everybody would do from point A, B to Z, but your point will come from Z to A. That process can be patentable. So if you remember Zendaya's Met Gala 2019 outfit, the one Tommy Hilfiger did, where she went as a princess, there was a magic wand, and then the magic wand would light up and the whole thing, was just very different. That is something that can be patentable. So that whole process can be patentable. And then the dress and the look itself can then be designed. So if, the positioning of the court was very different, then that would be designed. So those are the very major differences. So the process, for example, of that lighting up on the wand would be a patent, and then the outlook itself, the get-up, would then be on the designs.
Okay, understood. So Laduma, why is it difficult? So you're channeling traditional Koza beading. It's the biggest tribe, the 3rd biggest tribe, you said?
Second
biggest tribe. So that means you and a whole bunch of other people can tap into this culture. It doesn't belong to Laduma, it belongs to the Koza people, right? So if someone else woke up today and said, I'm also going to interpret beadwork and I'm also going to put it on rugs and stuff, could you curb that within your market, within your space? Because and they said, okay, don't worry, I'm not trying to show mine in Cape Town. I'm just selling mine in Joburg, or I'm only selling mine, like I'm only selling mine locally. I'm not exporting. Why would it be difficult, or how would it be difficult to curb that kind of copycat behavior?
I think for me, in my personal opinion, marketing plays a big role, as well as branding. I mean, anyone can wake up and take French tradition and try to emulate Louis Vuitton. But they can never take the actual DNA and the elements that you see when you decode that brand. With that said, I think there's nothing really much one can do to avoid being copied or someone taking your idea and modifying it. But if you as a designer or as a brand you have done the groundwork and actually became optimistic about how you manufacture, for instance, and how you play around with your colors and how you package and how you package your experience in your retail space. Those type of unique elements would be the one that would make the customer, when they pitch up in a sales pitch, they'll be like, this is not the product that I saw online, and this is not the aspirational product that I'm looking for. And therefore they will turn their back and go to the actual brand promise that they were seeking. And that is how we've managed to cut through a lot of distractions that are out on the market. And positioning also plays a big role as well. We on set went straight and knew where we want to position ourselves and said that we are not a curio brand, we are an African luxury brand. This is what we specialize in and this is what we do. And we use premium quality material. And we did the whole process 10 years ago of registering our designs with the biggest IP firm in South Africa called Adams and Adams. And we've had a lot of cases in the past. I've had a lot of cases with Zara and a lot of outlets that have tried to dabble with my artwork. And I've won most of those cases, all because I developed a personal DNA. And that I think is the best way to protect yourself, and by stamping your own DNA and not taking a generic idea that people can hack any day. That is what I would recommend that one takes as an approach.
Thank you. There's actually so much to unpack there. And I want to start with just summarizing, right? And what is really important, because having your creative DNA, your design, and positioning yourself in the market at a particular point, you took the time and the expense at a time when it was probably a gamble to also pay for the premium legal advice that would actually set you on the right path in the first place, right? And so just those are sort of the three things that stand out, off the bat. But I actually want to address something, because you raised one of the major brands that has attempted to dabble in, in Makuza Light. It's funny because Kike and I had a previous conversation about this, and one of the things that came up was there are actually two types of copycatting, right? And I think from a legal point of view, they're probably both bad. But because we're now talking about perception, it's interesting because somehow or the other, right? A big box brand ripping off an independent designer, tapping into his heritage, that's bad. Everybody agrees that that is terrible, right? That is just wrong, and that's sort of capitalism writ large. But when a fast fashion brand rips off a heritage designer, you've also mentioned one, with clear DNA, and so a jumper that's going for €1,000 gets replicated and can be sold for $49.99, and so everyone can aspire to the look, and it goes on a steal versus splurge page. Why is, and Toby, I want to ask you because I'm curious, they are both, we've ripped off the same thing, right? But why is one okay and the other not? Like, why does one get a pass and the other, is seen as especially heinous?
Yeah, thank you for that. I think and the question, I think the way you phrased it at the beginning, it's not like any of them is good, and I mean, it's not like either of them is good. I mean, because what we see though is that a lot of contention plays out into public morality. You see that even in the design world, there's a lot of public perception that plays out. Of course, both are not accepted, but you see the dynamic of a big player ripping off a small player. I mean, it plays into public sentiment and drives conversations in a way that's very harmful for such bigger businesses. So I think that it's not as though either is a good, but then we are dealing with issues that touch on sentiments as well. I touched earlier on around this traditional corporate expressions idea. And sometimes, like we see it play out a lot in those conversations where we talk about indigenous tribes being, having their own designs placed by bigger brands or bigger designers without any form of attribution or compensation going back to them. And immediately that plays out into some bigger narratives, which drive into the emotions of people. And so I think it's just the way the society responds, and I think the law always responds in that direction.
Okay, so, but do you mind, Busola, what's the infringement? Because it's the same infringement, right? What is it? What is that? I don't want to say crime, but what is the offense that's being committed when this happens?
So I think we need to separate knockoffs, right? Yeah. So we need to separate that. And because we've been mentioning a particular brand, maybe that brand, we are all, aware that they do quite a lot of knockoffs with big brands. I mean, I patronize that brand a lot, so I'm not going to knock them.
Is that passing off? Or what is it?
So it's not, it really like a knockoff. So there's a t-shirt that it has like a flowery print, or what would I say is really trendy now. I mean, Kike can help in that regard. So, if there's something like a flowery t-shirt, Gucci sells for £1,000, for example, it has this really nice design. And then Zara decides to make a flowery design shirt, with blue and black, which is the color that, and then makes a knockoff of that. So it's not passive, it's a replica, right? People that know would know the difference, that kind of stuff. But we then start to see the similarities. So that's a knockoff because Zara hasn't branded their product as a Gucci t-shirt, for example. It doesn't have a Gucci name on it. It doesn't have the Gucci logo on it. The positioning can be different, but we can see similarities. The colors might be different. So that's really a knockoff. When it now becomes a real infringement or passing off is when someone decides to then put the G upside down somewhere behind or beside the exact green and red, the colors of Gucci. They decide to put it on the side. Then we start to talk about infringement, or the colors that Gucci used exactly. Then we start to talk about infringement, and then Gucci can then start to. So we have to separate what knockoffs are and then truly passing off an infringement. And to what Laduma said, and that's why it's important that you have to put a lot into your designs, you have to invest in them. It's very, very important because it's not easy. That's why some designers actually sit with experts that come up with their logos and their patterns and their colors. Because once you have invested in them, and that's the recent case of Fisaya Lunge, the Kai collective, because she truly invested in, coming up with that pattern. So it was very easy for all of us to see, even if she didn't want to do anything. I'm sure there were people who would have said, I mean, this is a Kai collective outfit. So she really invested in those patterns and took steps to protect them. That's very important. So just investing in that pattern, investing in that design, in that color. If you look at the Versace Medusa motif, for example, we can all, we all know by just seeing, like, if you see a Vera Wang wedding dress, just before they say this is a Vera Wang, you already know that this is a Vera Wang wedding. So invest, in those designs, and and the patterns or the process is very important. But yeah, there's a difference between knockoffs and infringements.
Okay, thank you. So Toby has said that law tends to follow the human sentiment in a way, right? So that's why the issue of power dynamics are addressed, and really and truly, someone getting a $29.99 t-shirt to wear around versus 1,000. She doesn't have it. That her whole budget for the year is €1,000 for her clothing. So, but she wants to tap in a little bit to some of that, right? So, I think I want to talk about the steps. I want to iterate because we did agree that this was for knowledge sharing, for people to understand exactly what they can do. So, we've talked about the steps designers can take, and Laduma has pointed out that making sure that your design aesthetic is unique to you and is relatable and identifiable is very clear. Busola has pointed out that you will have to invest in the legal expertise to really secure that, so that you can defend the inevitable copying, because with success comes imitation. It's the sincerest form of flattery, etc. So, but by making sure that everything is definitively yours, definitively unique, you make defending and curbing copying a little easier. I think another creates a practical step, and we're seeing a lot more of these, and the bridge between big box fashion and high street and independent designers. So we're seeing a lot of collaborations, right? So designers are using some of their unique pieces. Makosa, what do you think about that? We're seeing a lot of those. I know that there's a South African brand that did something with H&M a few summers ago. I know that Debenhams, which is a big UK chain, actually aggressively pushes a particular subset of designs. So is that an attempt to sort of, for independent designers to perhaps harness economies of scale, push out their designs, prevent being copied? What's the rationale being? What's the business case for those kind of collaborations? That question was for Laduma.
Oh, was it for me?
Yes, it was.
I've been watching from a distance, these great opportunities that the likes of H&M and other big chains that have been giving opportunities to young designers to give bigger distribution. But for me, what I dislike about it is that is the short-sighted, short period hype about it. And as an entrepreneur, I also question myself, is that what type of compensation? Was it a royalty base, or was it a commission based, or what was the setup? Do they keep their copyright and whatnot? But nevertheless, we do have H&M in South Africa, lots of them. We do have Zara's, lots of them, and Topshops and Gucci's and Louis Vuitton, but it is still difficult for local designers, especially Black designers, to get into the retail spaces that these big brands are competing on. For me, I think that the biggest form of support will be that is for local designers, African designers, to be given those platforms where they can give you a store within a store, where you are able now to compete with other designers or other sub-brands that are within their retail space. But yeah, nevertheless, it is a space that we are slowly penetrating. Last year, July, during lockdown, I opened my small boutique next to Montblanc, Gucci, and Louis Vuitton in Cape Town at the V&A waterfront. And I've got a 200 plus minus square meter boutique here in Johannesburg. The time for waiting for handouts from big brands is over. Yes, they do want to tap into our creativity, but the argument becomes so difficult when it comes to long-term opportunities and remuneration. But you take the leap of faith and take a high risk and try to be involved in a value chain, and that's where we get beaten the most, is that as much as you have a good brand, a famous brand, but you're still sourcing production from an Italian somewhere, or you're still sourcing raw material from a Mughal. So yeah, that is what's happening in that space right now. There's some sort of uncertainty as far as distribution is concerned, but all in good time, we will be aligned and know where we are destined for.
Thank you. And you raised something that I think perhaps when I was doing the thinking about it, and Toby had also actually referenced it, I think something in particular that we have to address, and I think it's almost impossible to have a conversation about anything Africa and not acknowledge the history of our raw material, our resources being tapped and then sold back to us as finished goods, right? And I think to behave as if our creativity, our design, our joie de vivre, our swag, isn't also uniquely a resource in that way, I think is somewhat, I think one must put that into the context of when we talk about protecting creativity, we must acknowledge that there are some creativities or creativity that is uniquely African that, and that comes across in almost everything we do. You can tell an African, even when they're dressed in generic clothes, they're in jeans and a t-shirt, and there's something about them that you can, there's a way that the t-shirt will be tied or will sit that will show that it's uniquely African. So I think trying to situate this without taking that legacy into account might not be entirely accurate. So thank you, Laduma, because you've raised particular issues that are very germane. We can't continue waiting for handouts because the way to ensure the purity and sanctity of the creative process is actually to own it end to end, right? So that probably opens up us more to sort of the business aspect of things. And the reason we're having these conversations, because our businesses need to be investable. We need to know our numbers. We need to know how we want to scale. We need to know who we're selling to and what exactly we're selling. So I think that is really, really important. I want to actually ask for people to ask us questions because you guys are experts and there's a lot of knowledge. And I think one of the...
Can I
yes,
say
of
something?
course.
To
please.
What you're alluding to is actually very important. I think Ogun State is already doing that. And Toby mentioned it as well when he talked about traditional knowledge and traditional cultural expressions, which are very, very important. You go to a Selfridges, for example, and you see a Ajire being sold for £600. You're wondering if the man in the States got a cut from this. So again, it's because our laws really don't have provisions for traditional expressions or traditional knowledge. So like the Maasai people in Kenya, they have come together to protect, because Kenya has the laws for traditional knowledge. So they have come together to protect just the knowledge about Maasai people, the way the Maasai people walk, the red, almost like the red, really nice fabric that they use when they're walking. So those are the kind of things. And like I said, Ogun State is already doing that when it comes to Adire Ogun. So, those are the kind of conversations truly that we should be having as Africans, is how do we protect this traditional knowledge that we have, that, like you said, they won't take it from us, finished product, bring it back, and then sell it at exorbitant rates. So, I mean, conversations like that should be had. I see that we're already taking steps in the right direction. So I just, thought that I should throw that in. If, you wanted to say something?
Yes, because I want to know if I've been a good student today, because one of the things about our traditional fabrics is not traditional fabrics. So, I mean, am I correct in saying those could be protected in some way? So our traditional dyes, our traditional techniques for batik, our traditional, because you see Indonesia, Indonesian batik, it's a particular technique. Ogun Adire, as you've said, tartan, even Italian cashmere, Scottish wool, they've all done. So is that where the protection would come, the creation, so we're talking almost before it becomes apparel, we're talking about the source materials, the fabrics, the designs, the patterns, those could be done in that way. Is that what we're saying? That's where the protection would start from?
Absolutely. Like, I know my mom was telling me that the way Adire is done in Ogun is very different. The process is very different from it. Those are the kind of things that can be protected. For example, as certification marks, for example, where certification marks are this, originates from here, and anyone who decides to use this kind of fabric or this kind of product needs to get authorization from this community to be able to use such and call this the Adire Ogun, because everyone understands that Adire Ogun is very unique. So that process of making it, like I said earlier, can be a pattern, for example. Beyond the process, when we now start talking about the fabric itself, can be a certification mark where the community, the people of Ogun State would get monetary compensation for anyone who even just wants to use the name or just even wants to say, oh, my product, so there's so many dimensions, especially for intellectual property when it comes to the fashion industry. But again, like we said, our laws need to evolve to this time, to the 21st century, to what is happening around us. The laws really need to evolve, but not be that as it may. People, fashion designers, for example, can take advantage of various laws. They need to understand that various laws can cover it. So you don't wait and say, well, the laws, cake, there's so many things you can take advantage of whilst you're still waiting for the laws to evolve.
Okay, awesome. I've kind of opened it up for questions because I think, that's why we're here. Oluwatobiloba Olabi asks, and I want to leave it open to whoever feels that they want to answer it. Would it be wrong for me to use photos of some designers' work from their website, Instagram, Fashion Week in a blog post on fashion trends with analysis? The purpose of the blog is to highlight a trend, so credit would be given to the designers. I'm an illustrator and a tech lover working on pursuing a degree in artificial intelligence and data analytics, and I want to apply it to fashion trends and sales forecasting. Kike?
Okay, yeah, I actually get this question. So it's they're quite used to copyright. And if you're going to use someone's copyright, which copyright would be vested in the photographs that you're trying to use, if you're going to use anyone's copyright, ideally you should seek their permission first. Strictly speaking, using anyone's copyright without their permission is straight infringement. But as I said, copyright has some exceptions, and what you're trying to do falls within one of those exceptions, which is educational purposes. It's not a commercial thing. It's, one could argue that it's public interest because you are educating the public on something. But it is important though to credit the source of your images, just so that it's clear that this is where the images have come from and all of that. But if you're using it strictly for educational purposes, speaking on a particular topic, then it falls within the exceptions of copyright. But I always say, just be careful, make sure you're well versed on copyright laws. There's a lot of material on the internet. Speak to your lawyer friends, just be very careful when you're using other people's images. It's extremely important. I know that there's so many websites now that that sell, what do they call them? They are watermarked, but you can buy the images basically of the internet. Sorry, I'm losing my train of thought here, but there's so many images that you're able to buy without having to credit. And you're buying them for your personal use, for the use of whatever it is that you're trying to educate the public on. If you're not sure, just always ask, or always get the permission first, but don't just dive in into anything. So hopefully that answers your question.
Okay, thank you. I hope it has answered your question, Oluwatobiloba. Elogene Adaka wants to know, if design rights are territorial, can one get any compensation when they are infringed upon in a different country where they have not been registered? Busola, your hand is up.
Oh yeah, no, I actually wanted to talk about, but I can answer this as well. And Kike addressed everything I actually wanted to say, but I just wanted to add that you then have to really show that it's not for commercial purposes. So it's very important that even though you credit them, not that we can then now see that you're making a whole lot of money from their copyright. So you need to show that it's not for commercial purposes. And to answer this question, so if your design, yes, designs are territorial and you probably haven't registered in another jurisdiction, for example, but if you can show that, for example, I have been on the New York Fashion Week, on the runway, or I've sold my product, my designs in the US, for example, people from the US have worn my designs, we can then take advantage of the common law of passing off and say XYZ is passing off my design as theirs in this jurisdiction, even though I haven't taken steps to protect myself, but because of use by way of people wearing my outfit, use by way of me advertising, or use by way of they're just accessing my website in America, that can actually be an evidence of use. So we can take advantage of that common law right, and you can, take steps to protect yourself in that aspect.
Okay, so we've got a few more questions. Some things aren't covered by copyright, but are copied by things. I'm not sure I understand the question, but
maybe we let the person.
Yeah, maybe the person will clarify a bit. But there's another one that I'm loving. If we use these images in online courses that we intend to make subscribers.
Big no. Very big no. It's for commercial purposes. It might be education, yes, but it's commercial purposes. You're selling, you're making money without, and the person that owns the copyright isn't benefiting anything from it. So, well, and the whole point of IP. I think I understand what the other person was asking. Yeah. But I think the easiest way to answer this question is anything to do with images, photographs, all of that, they're copied, they're protected under copyright. So even if it's the image of a design, the image itself has copyright in it. So I mean, I could take a picture of Makosa's socks, for example, and know that he owns the industrial design in the socks, but the picture of his socks, there's copyright in there. So if I'm going to use that picture of his socks, I still need to speak to the copyright owner And that's always the photographer, not even him. It's the person that took the pictures of the socks, if that makes sense. So anything to do with images, photographs, anything like that, there's copyright vested in there. So you just need to seek the permission of the copyright owner. If you're going to use the design, then that's a different, thing altogether. But if you're talking about images, copyright.
Okay. So that's, obviously the Southwest design dyed fabric. And I think we've sort of said yes to that. Okay.
We need to clarify that because
it was actually forward because really question. Please, can the lawyers answer?
We need to clarify that because GIs are not, there are no provisions for GIs under our laws in Nigeria. And so if there are no provisions for GIs, the standard is that you'll use the sui generis. I don't know the English for that, maybe Kike can help me. But you use the laws applicable, what you have in your acts to protect that area, right? Exactly, that to try and protect that. So what we have in our laws with the certification mark, which I was referring to earlier, is what we would use in Nigeria, for example, to protect such, IP rights. So certification marks is certain people will come together, say this is how this, adire is produced, this is how it will run. If anybody else wants to come and, start to use that adire, the name, for example, the process, for example, they need to get a permission from us, and they can, they can then register those rights at the respective offices, and then they can start saying this product as well is from Adire Ogo. So you get that certification mark. So in Nigeria,
Thank you. There was the second part of the question. If I take a design created by a person I do not know to my tailor to make, am I guilty of infringement?
Generally speaking, yes. Generally speaking, yes.
Okay. So I guess my next question, and because I'm going to be that person, is, so we keep saying our laws are not there yet. Our laws, please, lawyers, what are you guys doing about it? What's the process from getting our laws there? I'm just asking. I'm not saying you have to do it, but I'm asking. If we're having this conversation and we're seeing that we don't have geographical, what is that we don't have geographical indication? We have to use what did you say we have to use instead?
Yes, certification mark. I mean, Toby can answer that question.
I was going to say, I think Toby is the best person. He's the WIPO expert.
I mean, we're here, like let it not just be talk and no do. What can be done to move things along? What are the practical things that can be done for the industry to improve protection for its practitioners?
Thanks. I think I was on the spot, but truthfully, I think like these kind of conversations are extremely important. I think on the one hand, there's a need for sensitization, awareness raising. That's a big part of lawmaking. Only yesterday, for instance, I came to get an event there, which was lots of stakeholders around conversations on geographical indication. And there was a lot of talk about, what's the future in Nigeria around geographical. What are some possible products? And interestingly, Adire was mentioned as one of those things that could potentially fit that bill, because of course, talking about the reputation linked to a particular location of the geographical point. And so I do think that these kind of conversations are extremely important. Another thing I should mention though is that as a country, we've also been working with the government around a policy, national policy for the country in the area of intellectual property. And what the policy does is it kind of feels like a long-term strategy around IP. And so different aspects of IP, it's a holistic approach being taken. So almost like all aspects of IP trying to be covered in this national IP policy. And with that, aspects like fashion, they have to be strongly represented, where the stakeholders need to be pushing a strong foot in those kind of conversations, such that the policy, once concluded, begins to inform the required legislative changes that are required to again support this kind of country. So maybe just two suggestions on that. Greater awareness through conversation, stakeholder gatherings, but also constructive engagement with the government around policy development. Thank you.
Thank you, Toby. Thank you, everyone. We're actually going to wrap up because we've done an hour. I think, we've really sort of tried to discuss these things in depth. In the interests of summarizing, I think what has become clear, and Laduma, your hand, is it up on purpose? Yes.
Yes, it was up on purpose.
Okay.
This wasn't an answer to any questions, but a heads up. These human beings, our fellow panelists, Tola, are very expensive people to hire.
Yeah.
so this was technically a heads up to designers. When you're a designer and you start making money and things are looking up, you forget to anticipate that these type of problems will come. People will copy your stuff and whatnot, and you have to pay them by hour, and they charge you for even having a phone call with you. So just a heads up to designers that when one does financial planning, all it simply takes is to make sure that you don't wait until you have a litigation. Just send them $10,000 every 6 months to keep in their trust account in case something comes up. Well, it's guaranteed that something will come up, not in case. So that's a mistake that we often make as creatives, is that we think that going on social media is going to resolve your cases, and launching a smearing campaign is going to go somewhere. But let's be realistic about the fact that we are in the numbers game, and therefore when you need armed forces behind you, you have to arm yourself financially. Thank you.
Thank you so much, because I was actually going to ask everyone for their sort of roundup, but yeah, I thank you, because really that, you've preempted it and you've made the business case for the Kikes, Busolas, and Tobis of the world, which is always important, we can't escape them. I should say, for what it's worth, my parents thought I was applying to law until my UCAS form came back with something else. So I was one of those people. So yeah, but I mean, thank you, because what we're saying is, and I think this is really important, what Laduma has said, and I think what he hasn't said is that you have to bet on yourself, right? If you are serious about this design game, you have to bet on yourself, and you bet on yourself in a number of ways. The first is being very certain and clear-eyed about your process, about your aesthetic, about your brand, about your delivery of whatever it is that whatever field you've chosen to operate in. So your experience must be that, because that can be unique. Your presentation can be unique. Your aesthetic, your palette can be as indicative of your personality or your brand personality as possible. But it's not enough to do that in its abstract. You must avail yourself of experts to interpret the law, because it's evolving, it's changing. Technology is really playing a very disruptive role in it. I mean, and it's not all bad. The fact that we're here able to have this conversation, to draw on these minds, right? You couldn't get this 10 years ago, right? You couldn't get this quality of conversation for free 10 years ago. Even 5 years ago, you might have had to fly to Lagos to have it at Fashion Week in a physical panel, right? So disruption is not always bad. It's giving us access. So this knowledge that we are empowered with, we must make the best possible use of. And so betting on yourself involves investing, not just in your machines and your tailors, but in your intellectual property so that it's properly defined and can therefore be protected. And you can't do that without lawyers. So you need them. So look at them and go and find them after this. But they're not doing, this was their free stuff. So after this consultation, I should just give that disclaimer on their behalf now that this kind of platform is what you get for free. Beyond this, things that will be specific to you, you need to bet on yourself, you need to invest in. That's the best way to protect your creativity. I think that's what we're saying. You need to invest in it from a delivery point of view so that your execution is uniquely yours. And then you need to take the legal steps to protect that in itself. These kinds of conversations, thank you very much to Lagos Fashion Week for this particular conversation, because what it is deriving is the content that will hopefully begin to push the law itself further so that there will be the trickle-down effect for everyone in terms of protection. So without further ado, thank you all so much for joining us. I hope it has been, I've enjoyed myself thoroughly. I hope everyone else has too. Thank you so much.
Thank you, Tolagbe.
Thank you. Thank you so much for having us. Thank you.
Thank you.